Welcome to the South Florida Roundup on WLRN. I'm Tom Hudson. Hundreds of thousands of public school students have to wear a mask when they are learning. Palm Beach, Broward, and Miami-Dade school boards have all voted to have children masked unless they get a doctor's note. The school boards are squaring off with Governor Ron DeSantis and the State Board of Education.
I would have never anticipated in my 30 plus years a conflict that would emerge that would definitely compromise the health, wellness, and safety of our children.
Parents, teachers, students, we want to hear from you this hour. 800-743-9576. 800-743-WLRN. School is underway in Palm Beach, Broward, and the Keys. It starts on Monday in Miami-Dade. It's all ahead on our program, made possible by Willie the Bee Man, bee removal specialist. Welcome to the South Florida Roundup on WLRN. I'm Tom Hudson. Thanks for listening this week and supporting public media. First, it was Broward County schools in South Florida having students wear masks in school unless they get a doctor's note. Then, by Wednesday this week, the school boards of both Palm Beach County schools and Miami-Dade County Public Schools voted to require students to wear masks. The Monroe County Public School Board is due to meet next week to reconsider its opt-out mask policy. Now, these actions this week, coming fast, mean that students in 3 of the largest 5 public school districts in Florida have to wear masks in the classroom or get a doctor's note saying they don't have to do it. The State Board of Education says that requirement, a doctor's note, has led it to find that Broward County's policy violates state rules and laws, and the Education Commissioner on this Friday, Richard Corcoran, has said that he will withhold money from Broward County because of its support of its mask policy. Now, as we are live on this Friday, we are waiting for President Joe Biden to make a statement regarding the evacuations of Afghanistanis and Americans and others from Afghanistan. You can hear and see that announcement live when the president makes it on our website. Just go to WLRN.org. It'll be right there on the homepage. Meantime, on the South Florida Roundup, we want to hear from parents and grandparents, teachers, staff, and students about schools and masks. 800-743-WLRN. 800-743-9576. You can send us your thoughts, concerns, questions at WLRN. How have you heard this debate over masks and this argument over whether or not local public school districts and school boards have the ability to put these kinds of mask mandates in place? We spoke with Vice Chairman of the Miami-Dade County Public School Board, Steve Gallen III, this morning. Vice Chair Gallen, welcome back to WLRN and the South Florida Roundup. You described this decision regarding masks in the classroom as, quote, bookended between whether or not we protect and provide for the health, wellness, and safety of our children, or whether we comply with an emergency rule, end quote. Now, that emergency rule allows masks in classrooms, so why do you think parents needed to be told and students needed to be required to wear masks unless exempted by a doctor's note?
One specific reason is that the executive order provided for a requisite opt-out provision. Mm-hmm. So to the extent that a parent did not want to wear masks, it was not a requirement in our district and in our classrooms. So the executive orders had that stipulation, and what the position that was taken was that anything outside of providing for an opt-out would be contrary to law.
Is the Miami-Dade position a reflection of a lack of trust in parents' ability to make decisions regarding masks and their children?
Well, I think it's not necessarily a lack of trust in terms of parents being able to make that decision, but we have to make a decision for the entire school district. And the parents at that particular time, they trust us to make decisions as relates to the safety, health, and welfare of our children. Let's face it, this narrative has been predicated primarily on parents who were opposed masks. Mm-hmm. But if you look at some qualitative and anecdotal data, we're hovering around 80% of parents that would like masks in the classroom and school environment for the protection of their children. So to the extent that we were looking at making a decision predicated on some parents, we have to make a decision on all parents and all students, and that's what that decision rendered.
Have you gotten a response from the State Board of Education?
Not at this particular time. We did anticipate, based on what had transpired in Alachua in Broward County a written communication, but to date we have not received anything as of yet.
The Miami-Dade policy does allow a child to go without a mask as long as there is exemption paperwork signed by a certified physician. How does a parent find that exemption paperwork?
That would be something that they would consult with their child's doctor, their pediatrician, and what we describe it as a medically endorsed accommodation. So it's something that is stipulated through a medical doctor. If a student has some condition that a mask would be untenable and would compromise his or her health, wellness, and safety, then that endorsement would be honored by our district and that accommodation would be made.
Is that endorsement in the form of a doctor's note?
Yes, yes, it would have to be documentation from a certified medical doctor. Absolutely.
There's no specific form that has to be filled out from the school district, however. Is that correct?
Yes, the district does have a form that we utilize as a standard form, and
Okay.
that would suffice. But a doctor's note would constitute the appropriate documentation accompanied by that form.
Do you think requiring a doctor's signature on a mask exemption is discriminatory at all?
No, not at all. When you look at the health and wellness and safety of the entire student population, I don't think it's discriminatory.
It does require going to a healthcare facility and perhaps requiring a payment for that medical service, does it not?
I would not want to get into the specific requests of a particular parent situation, but I think any student that has a medically endorsed condition, that's a condition that's already verified. And I think documentation would just constitute that verification. So what we're talking about, something that's medically endorsed, is something that is already established, and the verification process would be in place through the medically certified personnel.
I see. Can that medical endorsement be communicated via email?
We will require something in writing
Hmm.
primarily. I will let the administration make that
Okay.
determination, but we would have to comply with FERPA and the Family Educational Rights to Privacy Act. So when we get into medical records, we like to have official documentation. And I'm sharing that as a former principal of
Right.
10 years,
Yeah.
that we would not want to transmit information through email, medical information, especially that confidential information in that form.
Understood. FERPA is one of those privacy laws regarding
Absolutely.
students and education.
And email does not provide an opportunity to have original documentation as
Right.
well.
Right.
Email documentation would not be able to certify the validity of the documents that are being submitted.
So it's been less than 48 hours since the policy was approved by the Miami-Dade County School Board, your proposed policy. Do you know how many exemptions have been submitted?
Not at this particular time. Again, school is preparing to start on Monday. Our administrators and our teachers and our employees are at the school sites getting the facilities ready. That particular process for that medical endorsement accommodation will be dealt with directly at the school site initially. And obviously, as the fourth largest school district, we have over 300 plus schools, and that will be a decentralized process
Okay.
initially, and we'll be able to capture that data as it comes in.
So could you imagine, I suppose, on Monday morning, children showing up without a mask and a doctor's note to their school and having to turn in that paperwork to a homeroom teacher and then eventually to a principal?
Well, it wouldn't be a homeroom teacher. Actually, that particular process would be given to the person in our schools that has the responsibility and the role for facilitating that particular documentation. In many regards, it would be a register. And many of our schools, actually, when we start talking about administering medicine, we have a designated staff
Right.
who is actually assigned to administer medicine to students that may have to take a pill throughout the day. And there's training that goes with that. So these staff members are trained in that particular process, but in addition to that, they're trained in the obligation that they have under FERPA and provisions for confidentiality. So I would anticipate that's the process that will be in place, and it will be handled at the school site by designated staff under the supervision of the principal.
We're speaking with Steve Gallen, Vice Chair and District 1 board member of the Miami-Dade County Public School Board. It was his motion on the mask requirement that was approved this week by the Miami-Dade County School Board. You're listening to the South Florida Roundup here on WLRN. Dr. Gallen, does the governor's executive order, which prohibits mask mandates, in your opinion, does that order violate the constitutional provision that the state of Florida provide a, quote, safe, secure, and high-quality system of free public schools?
Absolutely. I think there are some conspicuous conflicts relative to the role and the responsibility of local school board members. And as you indicated, that is one of our primary duties and charges. When we talk about raising our hand and swearing on the Bible, our obligation and commitment to uphold the Constitution of the state of Florida, that is one of the primary elements of the Constitution, is providing for the health, safety, and welfare of our students. So anything that impedes, whether it's intentional or unintentional, our ability to carry out that particular and most primary function for health, wellness, and safety, I think it is, if not a violation, it is a direct conflict that has to be resolved appropriately. And I would say the statute, in some regards, had anticipated some conflicts to
Mm-hmm.
emerge, but I would have never anticipated in my 30 plus years a conflict that would emerge that would definitely compromise the health, wellness, and safety of our children.
It begs the question, and this has come up by the Board of Education hearings that have been held this week, or meetings, I suppose, is a more accurate description. Who's ultimately responsible for public education in Florida?
The Constitution specifically states that local school boards are creatures of the state. So we are an extension of the state. We definitely are. But to the extent that the Constitution stipulates that we are responsible for the oversight, the supervision, and the decision making at the local level based on our local conditions, based on our local demographics, and based most importantly on the local needs of our students. So to the extent that you have a universal system of education throughout a state to provide for continuity, to provide for some levels of efficiency, and definitely to provide for some levels of accountability, we have a shared purpose. And what I indicated in my remarks, one would believe that our shared purpose would be aligned when it came to the health, wellness, and safety of our students. But this is one where that purpose that should be shared has now come into some intractable conflict.
Well, let me ask, who do you think is the ultimate authority for protocols to control COVID-19 in public schools? A more specific question.
The local school board.
The Commissioner of Education in Florida, Richard Corcoran, said in a letter to Broward County that it's the Surgeon General of Florida who's the ultimate authority for protocols to control this virus in public schools.
Well, the school board has to adopt and administer and consider and contemplate the provisions that are outlined, not just based on the Surgeon General, but you have to also look at the Department of Health. When you look at the executive order and some of the discussions that have taken place, it was not simply the State Board of Education that was contemplated, it was also the Department of Health.
Right.
So they do have some protocols and some provisions and some input as it relates to things that we should consider. But again, those are recommendations very often, and those are recommendations that have to be contemplated at the local level based on local conditions.
So the Board of Education and the commissioner has called them requirements, not recommendations, to school districts to say that they are in violation of state law by only requiring or only allowing a medical exemption with a signed document from a certified physician in terms of mask requirements for students in public schools. Do you believe that what the Miami-Dade County Public School Board approved this week is in violation of state law?
I do not. I do not. I do not. I think the law does have certain requirements relative to our obligation under the Constitution. So what do? You juxtapose the Constitution of the state of Florida and you juxtapose that with a 90-day executive order. And to the extent that that conflict has been manifested, that has to be sorted out. And I don't think that disposition can take place by and through the agency that actually established and is in charge of administering the executive order via the State Board of Education. So I think that has to be something that has to be contemplated through an independent branch, possibly the judicial branch of our government. And I think that has to be resolved through the courts. And I think to the extent that you have that conflict, there are administrative procedures outlined in law as well. And the law stipulates that you have a DOA can seek to resolve some of these issues. That's the Department of Administrative Hearings, right, versus a State Board of Education that wants to be the body that establishes the rule and also make the determination whether or not the rule has been violated, and then make a determination as relates to what will be the punishment.
Well, understood. And this week, as you know, the State Board of Education did find probable cause when it came to Alachua County's mask policy as well as Broward County's mask policy. And the chair of the Florida Board of Education, Tom Grady, said the state had a range of punishments it could consider. Please listen to Mr. Grady.
It may involve withholding salaries. It may involve removing officers. It may involve public records requests to see how monies are being spent within the district, including whether they're being spent for public relations or political purposes. And I would also add a report to the legislature with recommendations for the legislature to act.
Dr. Gallen, does the governor have the power to remove elected school board members who voted for a mask policy?
The governor has wide latitude and power, but I don't know to the extent that Mr. Grady was reflecting what the governor could do versus what he thought that the State Board of Education could do. Out of those particular four options, I think only three really fall within the purview and authority of the State Board of Education. Yes, they can make a recommendation for the withholding of funds.
Mm-hmm.
And again, that's withholding of funds. That does not mean retaining funds permanently. We have to listen to the language.
Mm-hmm.
Any public member can make a public request regarding any particular issue of a public entity. So absolutely, they have the right to make a public information request regarding the expenditure of funds. They do have the authority and the ability to make a report to the state legislature. But when you have the chair of the Board of Education talking about the removal of officers, when that is clearly out of the scope and purview of their authority, again, those are things that one has a right to say, but it does not necessarily mean that it has any place in law or fact.
So you don't believe that the Board of Education of the state of Florida has the ability to remove you, for instance, for approving the kind of mask policy that you voted for in Miami-Dade County?
I not only don't believe it, I know they do not. It's not whether I believe it or not, they do not have that authority. The State Board of Education does not have the authority to remove a local constitutionally elected officer.
The governor does have that authority. Does the governor have the authority or the cause to take that kind of action against yourself, for instance, for voting for the Miami-Dade County Public School mask policy?
The governor does have authority. Whether or not he has the cause, that would have to be a determination made based on due process, based on finding of fact. But it's very, very clear, and we have precedent that the governor does have authority to remove elected officials, but obviously there's a process, and obviously there has to be a determination of fact finding for that particular action to take place.
Dr. Gallen, last year when the school board and yourself were considering when to reopen school buildings, the state education commissioner gave the school board a deadline or risk a funding cut. At the time, you argued the school reopening ultimatum did not represent an infringement on your authority as a locally elected school official. Do you believe the action by the governor over masks and the action by the Board of Education over masks infringes upon your authority?
Yes, I do. And those were two different scenarios. Last year, I was very articulate about that particular issue. I'm sure you may recall, because that dealt with flexible funding. And I was actually very positively I commended the state for providing that flexible funding option that was tied to the reopening plan. It was actually myself during the course of the meeting that many recall that I took the reopening plan in the meeting and I ripped it and shredded it in the meeting because I said the district did not have to follow it, but not following it would not make it eligible for flexible funding. So that was something that we did have to make a determination about whether or not we wanted to do. So I look at those two issues as distinct, very different, but relative to the health, wellness, and safety of our students, I think that is explicitly stipulated in the Constitution of the state of Florida with respect to the rights and responsibilities that we have. But again, the flexible funding option was very different. The reopening plan and timeline that the district actually committed to, whatever commitment that the superintendent submitted prior to the board approving, we had an obligation to honor that. And again, the provision of flexible funding by the Commissioner of Education with the support of the governor was something to be commended last year and something that I thought we needed to honor and respect on behalf of our children and at the risk of losing about $80 million.
Dr. Steve Gallen is the vice chair and the District 1 representative of the Miami-Dade County Public School Board. Dr. Gallen, thanks for your time. Have a great first day of school on Monday.